Here we are at the outset of our second panel, and the topic here has probably received the most attention within the IP world because it's a threshold issue that AI is presenting right now. In the copyright context, this would be a question about authorship and originality, but our topic is patent law. So we're going to talk about inventorship, a couple basic points to get us started, and then we'll hear from our panel. Let me introduce the panel members, then make just a couple of preliminary points to get us going. So first panelist we have is Professor Dennis Crouch from the University of Missouri School of Law. He is now the Judge C.A. Learty Professor of Law at Missouri. His first degree, bachelor's degree from Princeton, is mechanical engineering, and then his JD is from Chicago. Our second panelist is from the Patent Office, and she is a senior legal advisor there in the Office of Patent Legal Administration, very important rulemaking and oversight division of the Patent Office. And her name is Nalini Mummalaneni from PTO. Her law degree, JD, is from George Washington. Our third final panel member is Dr. Hao Yuan. We already introduced her. She's a PhD and a JD and a senior fellow here at the Berkeley Center for Law and Technology. So a couple of stage setters. First of all, the Paris Convention is our fundamental international treaty for patent law. And in Article 4, it provides that an inventor has the right to be named as such on a patent. And so the right to be named an inventor is pretty fundamental. You might call it kind of a patent-related human right. And of course, we know that's distinct from any ownership interest. The right to be listed as an inventor follows from the act of invention, and property rights, ownership, assignments, transfers, that's a separate topic. Second point is, in the first instance, in almost every patent system I'm aware of, the ownership does follow from inventorship. So usually in patent law, it requires a subsequent transfer to take title out of the hands of an inventor and put title into the hands of an assignee, typically an employer. And as you may know, at least in the US, there's a difference there between copyright and patent. Under the work for hire doctrine, according to the copyright statute, the employer or the work for hire entity may be considered, shall be considered the author. We don't have any provision like that in patent law. You've got to name at least one natural person inventor under current law. The super tool qualities of AI tools obviously have presented a major challenge to that, given that the Paris Convention requires that you name an inventor, and given that the definition of inventorship, of course, arose in an era when human problem framing and human problem solution with the assistance of various tools was naturally the norm. Now we have tools that arguably are moving more toward the vision, conception, the initial plan or blueprint of an invention, rather than a pair of hands or a tool to extend human capabilities in building out, or as we say, reducing to practice the invention. So we have a new framework that comes from the technology, and it's posing some doctrinal challenges, and the threshold issue is inventorship. So I'm going to let the panelists each speak uninterrupted for 10 or 12 minutes to tell us their thoughts on inventorship, both the current problems and perhaps some doctrinal proposals or solutions to address them. So Dennis, if you don't mind, could you grace us by going first, please?
Sure, I'd be happy to. Thanks so much, Rob, and thanks everyone for being here. I was thinking, I want to tell you a couple of stories. The first story comes from the Supreme Court's recent decision in Amgen versus Sanofi. So that's this year's one Supreme Court patent case. If you've been following patent law, you know that the Supreme Court invalidated Amgen's broad claims that were directed functionally to a broad genus of monoclonal antibodies that bound to a particular protein that had the beautiful name of PCSK9. The Supreme Court in that case said it wasn't sufficiently enabled because it was so broad and there was a narrow disclosure. Now, many of folks here are trained engineers. And if you're a trained engineer and someone asks you to create a monoclonal antibody to a particular antigen, what you might start doing, you might start thinking about design process. How do you go about designing an amino acid sequence so that it binds to PCSK9? But that's not actually how biotech scientists do it. Biotech scientists operate a totally different way. Here's what Amgen did. They took the antigen in question, this molecule PCSK9, and they injected it into a mouse that had been genetically modified with a human immune system. So they injected this PCSK9 in. The mouse's body saw that as a foreign substance, and the immune system started to operate and created antibodies to the protein. Amgen collected those, did some screening to ensure that they worked, and filed the patent. Now, I actually see this process as really similar to the questions that we're going to talk about, and we're talking about today, very similar to AI-supported invention that Dr. Hao just talked with in the prior session. In this case, the mouse has the skills to design antibodies. And Amgen came along and asked the mouse, hey, mouse, please design me some antibodies to this particular protein. Of course, in that situation, the mouse doesn't understand text prompts like Claude or ChatGPT or others do. But it was given a different prompt, right? In this case, the prompt of a needle. But that's just a different language, right? We inject this, we say, how do we make this? Here's your answers. In many ways, these biotech scientists, I think, are an early form of prompt whisperers or prompt engineers, right? That's how biotech has been operating for many, many years. Now, I told you the Supreme Court case, the patent was invalidated, but it was invalidated on enablement grounds. Nobody questioned whether the mouse should be listed as an inventor. This is one reason why many in practice, I think today, still see this as business as usual, that we can really kind of keep moving forward without making any dramatic changes in the system. A second reason for business as usual is something that I talked about in a 2022 book chapter that I think we're going to link to in the resources page. My chapter focused on something on AI and the concept of corporate invention. What I talk through there is in a sense that our current system, including right with cooperation, implicit cooperation, both at the patent office and among all of us, our current system really is in the midst of what we might call a don't ask, don't tell mindset. The USPTO is not asking for the level of human or non-human contribution. All we're asking for from the applicant is to name at least one human inventor who is willing to sign on, right? Or in the absence of that, that the applicant is willing to name and announce as the inventor. That process is really straightforward, especially when we're thinking about how most AI contributed innovation is happening today, where there really is a human in the loop who's at least asking particular questions and seeking particular innovations. But what really helps this along, what really helps it work extra well, is the changes to the law as part of the 2011 America Invents Act. Changes to the law like eliminating improper inventorship as a justification for invalidating the patent. And reducing the ability for someone else to come and change the inventorship, right? And of course, as Professor Mergis mentioned, right, the inventor has a right to be listed, but in our current scenario, and there's really nothing clear on the horizon that would change this, the AI, as the inventor, would have no standing to move forward and assert their rights to inventorship either under the US or international law. So the upshot of all that is that in general today, if you make a mistake in listing the wrong inventor, it's not the big deal that it used to be in America. With the one exception, if there's a human inventor from outside of your company, then you run into trouble. But so long as that's not the scenario, it has become less of a problem than ever, right? And I think that's why we have seen, in the past year, we've got lots of people thinking about this and kind of enjoying the thought process. But when you talk with most corporate counsel, most folks prosecuting patents, they're really not concerned at this point. I've got a project going on with a student who I asked to go a little bit further, and my law student Tim Knight worked with ChatGPT using just the Socratic method, asking ChatGPT questions like, "Hey ChatGPT, what's some device that should be improved?" We get a response. "Now ChatGPT, what are ways to go about improving this? Now act like an engineer. Tell me some other embodiments that you might create." Through a series of not very many questions, I really believe that Tim has created a patentable invention. Now, truthfully, ChatGPT sucks as an engineer. And so the invention is not groundbreaking, but I do think it's patentable. And I don't think that Tim really contributed in any way to either setting the problem or identifying the invention or telling how to make this or telling how to use this. Right, all key concepts that we normally think of as core to inventorship. We're going to file this and give it to Nalini and see what see what she says. Does it get it up or down? Right, or do we have enough human involvement or not? I have a really strong viewpoint, though, that I'll just close on. That I really believe that AI-generated inventions should be patent eligible in some form or another, either through our traditional system or maybe via some alternative pathway. Unlike the copyright side, on the copyright side, I believe there is a strong tie often between the work and the author, and that tie is important to our culture and moving forward. I don't really think that's true for the most part with invention. Rather, the key feature of utility inventions are the utility itself and the ability to distribute that. I'm really concerned we're at a crossroad, though, that the lack of patentability, I don't really believe it's going to really limit the number of inventions that are happening. But I do think it's going to have a big impact on distribution and disclosure of those. Companies across the nation are moving more and more towards secrecy protection, and I think that's a problem. All right, thanks, Rob. I'll stop for now.
Okay, that's terrific. A lot of good food for thought there. I think we're going to definitely circle back to the ownership issue, and you're kind of hinting around the edges at a work for hire concept for patent law, which has been talked about, at various times, but it may be quite ripe. But I think now the logical segue here is to Nalini, because she's been having to deal with a lot of these issues as a policymaker in the PTO. I think they're in a listening phase now. They're trying to get good ideas, and they're trying to see, what best practices are emerging. So we caught the office at a good time for this conference because they are all ears and gathering information. And so I'm eager to hear what Nalini has to say, and I hope we'll get some questions from the audience that will indicate some problem areas you hope PTO will take a look at. So Nalini, you're up. Go ahead.
Rob, there's some questions in the chat that you might want to talk about while Nalini is getting set up.
some of the audience members are aware that Dennis very carefully couched his comments that correction of inventorship is not a big deal in the US. It's proving to be a very problematic technicality that's killing more than one valuable patent in Europe, however, because the European rule is quite a bit stricter. And in fact, we here at Berkeley have benefited from that because in one iteration of the CRISPR conflict, the MIT and the Harvard people lost their rights because they didn't name the full team of inventors in the initial filing, which is a European bugaboo. Anyway, Nalini, have we got you?
Hello, can you hear me now?
Yes, great.
Awesome. Sorry for the inconvenience. I thought it was working before. Anyways, so the AI inventorship issue was brought up in a recent Federal Circuit case, Taylor v. Vidal. The Federal Circuit decided it in August 2022. Two patent applications were filed in 2019 at the USPTO naming DABUS, the device for autonomous bootstrapping of unified sentience, as the inventor. So one of the applications was directed to a neural flame, an emergency light beacon that flashes in a specific pattern to attract the attention of rescuers, and therefore it helps its users survive. The second application was directed to a fractal container, that is a beverage container that improves grip function and promotes heat transfer to increase the user's enjoyment. So both the applications identified the given name as DABUS and the last name as invention generated by artificial intelligence in the ADS. So a statement under 3.73C identifying Mr. Taylor as the assignee of the entire right, title, and interest in the application was filed. This usually, for those of you who don't know, this statement is filed when an assignee who is not the original applicant wants to take action in a patent matter during prosecution of the application. And an assignment document assigning the entire right, title, and interest of DABUS to Mr. Taylor was also filed. Mr. Taylor executed this assignment on behalf of both the assigner DABUS as its legal representative and on behalf of himself as the assigner. And substitute statements were signed by the owner of the machine. Now, USPTO issued pre-exam notices to file missing parts indicating that the ADS did not identify an inventor. Mr. Taylor, the applicant, petitioned the notices in these two applications, and finally USPTO denied these petitions. Our position is that the statutory language required natural person inventorship. We refer to the definition section 35 U.S.C. 100, which defines inventor as the individual or joint inventor, the individuals collectively who invented or discovered the subject matter of the invention. 35 U.S.C. 115 requires inventor to make an oath or declaration stating that the individual believes himself or herself to be the original inventor. Also, if you look at the references in 35 U.S.C. 100 and 101, which says whoever, and the 102 language regarding exceptions, obtaining such subject matter directly or indirectly from the inventor. All these support our position. And we have Federal Circuit case law also supporting this interpretation, even though the Federal Circuit case law was with regards to companies or legal entities. In addition, the USPTO regulations require natural person inventorship, and MPP follows Federal Circuit case law regarding inventorship, explaining that the threshold question for inventorship is conception, which is defined as the formation in the mind of the inventor of a definite and permanent idea of the complete and operative invention, as it is thereafter to be applied in practice. So using the terms mind, mental, etc., indicate that conception must be performed by the natural person. And a point to note here is that Mr. Taylor maintained that he did not contribute to the conception of these inventions, and that any person having skill in the art could have taken DABUS as output and reduced the ideas in the applications to practice. And USPTO did not challenge Mr. Taylor's representations. In September 2021, Eastern District of Virginia upheld USPTO decision, and the Federal Circuit affirmed this in August 2022. The Federal Circuit reasoning follows like this. First, the court said it did not have to analyze the nature of the invention or the rights, if any, of the AI system. The Federal Circuit also said our task begins and ends with consideration of the applicable definition in the relevant statute. And first the court looked at the Patent Act, 35 USC 100F, G, and 35 USC 115, where inventors and joint inventors are consistently referred to as individuals. Based on Supreme Court precedent, the court found that an individual is a natural person unless Congress provides some indication otherwise, and here Congress provided no such indication. And the court concluded that the Patent Act supports the customary meaning that an individual is a natural person, that is a human being. And the CFC did not address whether inventions made by human beings with the assistance of AI are eligible for patent protection. And then after that, in October 2022, Federal Circuit denied request for rehearing and en banc rehearing. Mr. Taylor filed cert petition to the US Supreme Court, and the Supreme Court denied cert on April 24, 2023. Now, as Professor Merges told, we are working on the next steps, especially regarding AI inventorship, where AI plays a role in the invention creation process. And in order to gather feedback from the public, we are using multiple avenues. So the USPTO announced the formation of AIET partnership in June 2022 under the leadership of Director Vidal. The purpose of this partnership is to bring diverse spectrum of stakeholders together to share ideas and feedback and to collaborate on the intersection of IP and AI and emerging technologies. So using this AI partnership, we explored inventorship related policy issues during a few of these partnership events. For example, during the inaugural meeting we held in June 2022, we had a panel discussion on AI inventorship policy. The third partnership event was exclusively directed to AI-driven innovation, where 3 panels discussed the issues regarding AI inventorship, the current state of play with regards to AI-driven innovation from the perspective of inventors and researchers in their respective fields, like the panel we had today, the first panel. And also we had a panel from the perspective of patent practitioners, which consisted of in-house counsel, tech transfer departments, and law firm associates, and how to address inventions created with significant AI contributions. We also had a panel that discussed IP challenges from AI-driven innovation from an enforcement perspective, like, for example, in litigation. Now, because we have the Federal Circuit decision limiting the protection of inventions and discoveries by natural persons, and there's a growing consensus that AI is playing a greater role in the innovation process, we issued an RFC regarding AI and inventorship on February 14 this year. The RFC asked 11 questions, mostly regarding issues involving AI and patent inventorship. We pursued 3 main avenues of collaboration. One is through the comments, written comments to the RFC. We held 2 stakeholder listening sessions, one on the East Coast and one on the West Coast. And we also asked for contributions to the Journal of Patent and Trademark Office Society. So we had very good feedback we received. Thanks to Professor Crouch, who replied back, commented on the RFC, and thanks to Professor Hao, who submitted papers to the JPTOS articles, and a lot of experts who weighed in on this issue. So we are continuing to explore, and we had the Executive Order 14110 that was issued on October 30th, which gave direction to the USPTO to issue guidance on these inventorship issues, and we are working on that right now.
Okay, very helpful. Let me just make a point about some of the questions coming in. So there's a couple of questions on details of the invention process, such as how we might fold in AI tools into our analysis of a person having ordinary skill in the art. I would like to hold that for the next panel when we talk about enablement and non-obviousness, where the FOSITA question is a very natural set of issues. Likewise, if we're moving over towards inherency under 102 or whatever, we're going to talk about those as sort of post-inventorship issues. So hold the thoughts, and I'll make sure we address them in the next panel. However, our final panelist has to be heard from. That's Dr. Hao. And I don't know if we've provided a link, but she's written a very excellent paper on inventorship doctrine, particularly the problem that some of you have identified. The crux of inventorship often under current law is conception. And now we have tools that are arguably much more a part of the process of conception than we've had in the past. And I think she's given probably the leading analysis of how we should approach that, what changes we might have to make. So Dr. Hao, it is your turn.
Thank you, Professor Mudges. I have a few slides, so I'd like to share screen maybe. Just give me 1 second. I'm trying to find. Yeah, thank you for having me on this panel. So Nalini gave a very thorough introduction of the Thyler versus Vidal case. And I noticed that in that case, the court also stated that, so today we are not faced with the inventorship problem with AI-assisted inventing process. So my own understanding is that, from our conversation from the first panel is that we're still a little bit far from the fully autonomous AI. So I'm mostly interested in this AI as a tool, as an inventing tool, and its implications on patent law. So one major AI challenge to the inventorship doctrine, in my mind, is this existence of inventorless inventions, even though we are still far from the fully autonomous AI. What do I mean by inventorless inventions? It means that in some circumstances, no human being in the loop can be identified as the inventor under the conventional inventorship doctrine, even though she has made a significant contribution to the claimed invention. And why is that? So if you could bear with me for a minute, there's a rich school of research studying human creativity from the perspective of cognitive science, including the inventing process itself. So here is an anatomy of a typical inventing process I showed in a class co-taught by Professor Mudges and me. I find it helpful because different than the convention of a problem-solving focused view, this school of thought, this school of research pointed out the importance of problem finding and problem framing in the invention. As you know, not all problems are readily presented in front of you. Many important ones in history, they have been discovered. So Einstein famously said that if I have 1 hour, I'll spend 55 minutes finding a problem, then 5 minutes to solve it. So the first 2 steps, problem finding and problem framing, which for the reason I'm going to mention very soon, largely state human beings' unique role still, and it's going to stay so for a decent period of time, are particularly critical to an AI-assisted invention. Not only because they would initially shape the direction of efforts using a term our 2 panelists used for panel 1 to steer this invention, but also because they help to narrow down the problem space within which the solution could be explored by the AI. So lacking capability to understand causation, it is very difficult, virtually impossible for contemporary AI to actually detect real-world challenges, despite its amazing capabilities shown otherwise, nor can they frame the challenge into a series of technological problems or questions to be tackled. So having said that, the contemporary AI could be excellent at predicting solutions in certain cases where the problem space has been properly defined, thus reducing the cost of invention. And crucially to me, compared with conventional lab tools, including some of the conventional computer aids, and probably also including the mouse, Professor Crouch talked about, we need to discuss, I need to ask him further on that. AI is now quite capable of narrowing down to just a few choices, that are novel, surprising, and potentially valuable. So I guess my point here is that the mouse, like how predictable, how much trust the human being could give the mouse. So I might be ignorant on that. But I'm looking forward to a little more discussion with Professor Crouch on that. I found that metaphor very interesting. So I don't have time to go into this, but Professor Julia Pohl, who was a Turing Award winner, he wrote an excellent book together with Dana McKenzie in 2018, the book of Why. Many of you might have read it. It gave an excellent account of why contemporary large big data-based AI has a weak capability to grasp causation, but meanwhile can be remarkably good at detecting correlation. That is the technological basis for our legal discussion. A good example is AlphaFold, and also is progeny. I saw a lot of progenies AlphaFold, like IgFold, also the Ali's research in Profluent company. They use this kind of AI tools to design protein-based or antibody-based drugs de novo. Very exciting. So in a nutshell, this 3D protein folding problem has haunted biochemists for decades, and the highest human record with traditional computer aid was no higher than 40%. If we look at the figure on the right here, that 2016, that was before AlphaFold came in. Nevertheless, after 2018, and particularly in 2020, after human researchers in DeepMind, they framed the protein folding problem into an AI prediction problem. Ali also gave an excellent explanation of some of the details of that framing in panel 1. So the AI came up with a prediction of accuracy rate of 93%. So and this has a lot of implications in my mind in patent law doctrines. So what do I mean by that? As Nalini explained, conception is the touchstone of inventorship. So many of you are very familiar with it, so I'm not going to bore you with this. I just want to point out that case law taught us that conception is complete only when the idea is so clearly defined in the inventor's mind that that only ordinary skill would be necessary to reduce the invention to practice without extensive research or experimentation. So the interesting point here for me is that if with accuracy rate higher than 93%, if current AI is capable of achieving often, so can we say that, leaving the fact that AI doesn't have a mind, we already conceived of the idea in its, mind, not a real mind, but in a computer. So this would be the major difference I see from conventional tools. But on the other hand, merely posing the problem to be solved or suggesting a desired result to be accomplished does not constitute conception. No matter how specific the identified problem is conception does not happen lacking a settled and operative solution. So in this new inventing synergy that we are seeing rising, in front of our eyes. If human researcher only found and framed the problem, she won't be inventor under the traditional doctrine. So on this, I think the 2000 Federal Circuit case, Singer versus Brake, really drove the point home. In this case, the court observed that in Singer's notebook entry, he articulated a specific problem to be solved. Specifically, he noted that first, the 8 extraneous amino acids present in this IFND generated by the P60 DNA construct. And second, the 24 unwanted nucleotides that code for those amino acids with a notion sequence to be moved. And 3, the 12 nucleotides that are immediately upstream and the 12 nucleotides immediately downstream of that segment. So the court stated that, however, we agree with Brake that substantial evidence supports the board's finding that this entry alone was insufficient to corroborate Singer's testimony that he conceived of the invention because, quote, while clearly he articulated the problem, the entry did not provide the solution. So how do I address the problem of inventorless inventions? My own proposal basically is to expand this conventional concept of conception. And on that, I propose that the human researchers of this new human plus AI inventing synergy, I personally call it a centaur synergy because of the remarkable horsepower of the AI. So human researcher can be deemed as constructively conceived of the inventive idea if he or she simultaneously fulfills the following 3 preconditions. So first, she is the one that discovered and defined the specific problem to which the AI eventually predicted the solution. And second, she is the first human being that grasps the inventive step or non-obviousness of the specific and settled idea of the solution. And third, she makes an adequate disclosure of the AI's specific role in the inventing process. My time is limited, so I can only flag there. I think my proposal has a few advantages. The first is that it acknowledges human beings' unique role of problem finding and framing in this new inventing paradigm. I think that's particularly important in the AI age, and I further discuss it in panel 3 when I discuss non-obviousness. And secondly, it put human agency at the center, which is crucial. And third, it leaves space for the argument that, my own argument that non-obviousness doctrine should pay much more attention to the problem finding and problem framing part, particularly in the AI age. And again, I'll further discuss this in panel 3. And 4 is supported by deeper IP principles, such as the principles of dignity and efficiency. And last but not least, in my mind, it belongs to a kind of moderate change. So compared with more drastic proposals such as artificial inventors, or just leave those inventions in a public domain, I think this would be a change in a common middle ground shared between, IP utilitarians and IP humanitarians. So maybe more consensus could be built for it. So that is my 2 cents. Thank you.
Great. Okay, very helpful. Can we
Stop. Sure.
That's it. There we go. Okay. Lots of good questions. But before I get to those, I'll turn it back to you, Dennis. So if we were to convince Nalini that constructive conception is the right doctrinal modification, and she talks her colleagues into that, Does that solve your RA's problem? Does that easily make your RA Tim the inventor in his Socratic invention project?
And so, so I think that if we follow Dr. Hao's model, Tim is not an inventor.
Not? Okay.
No, because in my example, and Tim's watching now, Tim, I hope you don't mind, we're using you as an example. But because we particularly designed this where Tim did not identify a problem, Tim had the AI identify the problem. And then identify several problems and then explore each of those. And I think, right, and I believe that problem identification is huge, and it's an area where AI is largely helpful, right, helpful on both problem identification and solution. And so yeah, we do have a gap there. And in general, I agree that right now, what we've done is beyond what, right now, things are really being guided by humans. And so most work today would fall within the model. But next year, maybe a different story.
Okay. It's always a danger when you're dealing with a new technology. You want to address the problems that people are worried about. And there's always a stir of activity. You remember the DMCA in 1998 was the topic of the day. But you also have to worry about getting it wrong or locking in. And again, the DMCA would be a good example. Now when we look at the justification for shielding online platforms from liability, the infant industry rationale doesn't seem to apply too well to Google and Meta. If that's an infant, that's a real big baby by now. We got a giant baby on our hands. So the problem is to address the concerns without locking you in to a solution that's going to be time limited. And I think that's a fundamental problem. But let's go back to some of the questions, and I think I can ask all of the panelists this. So how necessary is it to continue the tradition of naming a human inventor? Are we at a point where it's time to move on from that? Or do we have anybody who would voice the opinion that would, whatever that would be, it wouldn't be traditional patent law, that patent law is about human invention and it should remain that way? So I think your position's pretty well staked on this, Dennis.
Well,
Nalini probably can't take a position, but I wonder if she has any thoughts on the problem. And Dr. Hao, I think you've tried to find a middle ground. And the question is, will that middle ground be persistent, or will it be eroded away by changes in the technology? So we could just start with Nalini and say, how do you frame the problem of is patent law really about human invention? Now, you might cite the statute in various places, but I'm trying to get you to go a little beyond the text of the statute and talk more about the understanding of what the field in general is all about. To use the Greek concept, what is the telos? What is the purpose of patent law? Is it to serve human invention and to honor human invention? Or is it in a completely utilitarian way just to get the maximum new technology for the minimum social cost, however we get it? So thoughts on that?
Yeah, so this question we asked in the Inventorship RFC, and we received like a lot of responses. Like many commenters said that we need that human inventorship aspect, because to attribute for multiple things, one for policy reasons, as you just pointed out, and some of them are for just pure being responsible for their contributions to the society, right? And most of them said that there should be no changes in the law where the different aspects, like where you can add AI to be named as an inventor or completely get rid of the inventorship requirement. and name only humans as inventors, right? On the other side, some people thought that it's outdated and we do not require human inventorship, or there may be more trade secrecy, as you were pointing out earlier, Professor Crouch, where if you are not capable of naming an AI as an inventor, maybe like companies or individuals will resort to trade secrecy and will not disclose their inventions or try to patent their inventions. So of course, like we have a policy goal of promoting innovation as the patent office. So we are carefully considering like both ends of the spectrum, like what is the middle ground.
Okay, Professor Hao, so what about the problem of we'll solve today's issue with a doctrinal twist, maybe constructive conception, but what if in the future we just right back to the drawing board and the technology changes and yesterday's fix seems to be in trouble or doesn't solve today's problem? Have you got any thoughts about that?
Yes, I thought about it a lot. There are actually in a nutshell, there are two layers to my answer to that. The first is regarding the consensus again. So like Nalini pointed out, even in the US, traditionally it's considered to be a more utilitarian country, and a lot of people think we should really keep that doctrine, which maybe has a rich humanitarian root that we have to name a human inventor. But I also worry about international convergence. Like, a lot of countries in Europe and in Asia, they are more towards the IP deontologist foundation. So this would be a huge, drastic change to them. And so I think, I don't have enough time to go into the importance of international convergence on this, but I think that would be a big problem too. And the second layer is my personal view. So as a human being is that I think, like I said, I think we're still a little bit far from fully autonomous AI. I personally think this is because of some underlying technological reasons. It's not going to change so drastically in the next year or even in 2 years. But leaving that aside, that's a could problem. But my second question is, if we can do that, do I really want a future like that? I think I have a little bit different view than Professor Crouch on this, because to me, to invent, even though it's different than to write, but still, to invent and to play a significant role in the inventing process, really that creative process is part of the essence of me as a human being. I don't know how much of this came from my physics, my technological training. I spent 7 years working in a clean room. I just feel that that's part of who I am too. So I guess my comment is that I don't really want a future personally that I don't need to do anything. The AI does everything. And I just, even though I can get some kind of compensation like from AI tax or something, but it is so crucial to me as a human being. Thank you.
Mark, can I just jump in briefly? Because I also love human inventorship. And for me, this is a difficult topic because I see this as mythic and a key element of our story. And I think it's a key driver of dreams of people around the world. And so I am concerned about releasing it. And in many ways, I see it as like a miraculous feat that we continue even today to have human inventorship. If you just think about it, right, when the system was created, we didn't have a corporate system. Today, if you work for a company, you build something for that company, the company owns it, right? You build something, that company owns that thing. Always with trade secrets, the company has owned the trade secret. The company has owned the trademarks always. And right, and as Professor Murr just mentioned, once we move to work made for hire, the company automatically owns those and is the author. it's like a miracle that this is the one little vestige where we still pay homage to the human. And so that, right, that I think is concerning, to let that go and see what happens. But I also see the other side, that I foresee that we're going to get really valuable innovations, and I want those to serve humanity in the best way possible, and encourage those innovations and encourage their distribution.
Yeah, in addition, if you have like a couple of minutes, so we held a panel in Dallas, like one of the AIET partnership series, and there the tech transfer specialist exactly pointed out to what Professor Crouch is saying, where they have their incentive structures in place to connect like the inventors versus what patents they're applying, right? So they have all those incentive structures in place, and therefore they strongly advocated towards having human inventorship requirement. And to come to the third element of the constructive conception concept that Professor Hao suggested, we did ask that question in the RFC about AI contribution disclosure, and we had like most number of organizations and companies thought that it was unduly burdensome to the applicants and the examiners. Some of the problems they told were it is a subjective and challenging task, and it defining the AI changes over time as the new model comes in and as more updates are being made to it. And also like they express concerns about why don't we have this kind of disclosures for other technical tools, complicated technical tools? Why do we have it for AI? And they also mentioned the time and cost. But we had a lot of individuals say that, yes, we need such disclosure contributions that will make it more transparent. It will serve the enablement requirement and written description requirement also, which you may discuss more in the third panel. And also, they said you can do it with the current provisions like the Rule 105 or under Rule 56, duty to disclose, etc.
Okay, well, the IP system has engaged questions that are not too different from this one at various times. And this split between, the utilitarian kind of an approach and what Dr. Hao called the humanitarian approach is definitely part of the history of the field. And of course, one of the classic places where that argument played out was with the rise of moral rights and the authorship-centric view of copyright, which, as most of you know, is the predominant view in continental Europe. So the conflict between that and the kind of let's just maximize the number of high-quality creations at the lowest social cost, that is definitely part of the philosophical tug of war that has always been part of the field. And if you're interested in that, I'll give you a shameless plug. Here's my very long and not very interesting take on that set of issues, a book I wrote some years ago that talks a lot about the different foundational justifications for IP. It's not a new problem, but I think it's sharpened. And a lot of times, new technologies have this salutary effect that they cause you to go back to the philosophical roots of your field because they present such fundamental problems. And I think this is really at the level of fundamental problem. I think from practical reasons, there'll be a lot of pressure to reduce the need to identify a human. But I think there will be always a dissenting, maybe a resistance to that, from other quarters. So I expect that to play out in a similar kind of way. So one question that did come up that I think we can talk about generally is if we decide that the practical constraints of the situation require us to ease off a little on naming human inventors, then we do have to ask the question of whether AI-assisted inventions require a patent in order to call them forth, it goes back to the incentive story about patents. If the technology is so fruitful and can arrive at solutions for not much cost, the question really becomes, do we need patents at all? Or do we now have an invention machine, a magic invention machine, which we can just turn on when we need a new invention, and no special, legal reward or recognition is required? So I put that out there. Even if it's not fully autonomous, if the technology can basically give us fruitful, inventive contributions wherever we turn it, wherever we direct it, then it does go back to the fundamental need for patents. The question is, do we still need them? And people have been talking about it facetiously in the comments, but if you follow it, you can see they're onto something, which is, how do you incentivize AI? Do we need to incentivize AI? Do we take the incentive story back a step and say, no, the incentive is to create the invention machine, is to create the machine that gives the answers? And then we're back to the question Dennis raised, others have raised: would trade secrecy be adequate? Will it be superior? That, if you think about it, might implicate what business models will arise. And that may differ in applications of AI that are vertical applications like AlphaFold versus investments in general purpose invention technologies, which can be turned in any direction and are not vertically specific. So I throw those out there as strictly incentive stories. Have you given that any thought, Dennis? Now we're going to talk about the next
Right.
panel. So you
Absolutely.
could say, well, we may have to raise 103 to preserve, the structure of the patent system. Have you given any thought to that, though, about the incentive story? Do we still need patents?
Yeah, absolutely. And I think, and I think you're going to get into it next story, does this practically change the level of skill in the art?
Yeah.
But, in general, I like, to link in with another, your most recent book on the history of IP, which is also really excellent. If we go back to kind of our founding, where we've got this line, the goal here is to promote the progress. And so thinking through what incentive structure works to get to where we're wanting to go, in a sense. And of course, at that, I think it's useful to reflect back that that in many ways, this is an exception to our notion that we should have open and free competition without government-granted monopolies, that we have this as a limited exception and before moving forward. And so all of that comes together to suggest, look, if we can do this, and certainly if it's accessible for anyone to easily do things, or anyone with $1 million to easily generate inventions, maybe we don't need, this this patent structure. Maybe we need to really think about how what does need incentives.
Yeah, which is a lot bigger than a single rulemaking. That's going to really shake the foundations of the system.
That's the problem, and it's the beauty of Dr. Hao's approach, that it's much more confined. Yeah.
If I could quickly add on that, I think, it's a great question that it's difficult to incentivize the AI, but there are a couple of layers of answers to that. The humans in the loop first can still be incentivized, and whoever that's the AI owner or the user, for various reasons, I put a cap on the user. I talked about in a paper, didn't have time to go into this. But the second to that is the incentive theory is not the only justification for patent, even in a utilitarian perspective. Professor Murgis and I think Professor Peter Lee from the third panel, they did a lot of work in addressing patents transactional rules, regarding the distribution of the technologies and market transactions. And so to me, that it's very helpful to think of patent in this light as well, because many of the tacit knowledges you can't really transact them, but patent would provide a good vehicle to, combine those and further market transactions. So there are a whole bunch of stuff in that. I don't want to prolong the discussion, but I just want to point out that's the second point I want to make. The third point is that, again, I'm not a pure utilitarian. So I do feel, in addition to incentive and also the other functional roles, there's maybe a more Kantian part to the story, that it is so essential to me as a human being, and it just deserves to be recognized by patent, by IP system. That's my 2 cents. Thank you.